Good morning, members. We have already formed a quorum. It is also time to start the meeting. First of all, let's elect a chairman. Hands up, please, for nominations. Mr. Andrew Leung, Wong Ten Kwong. Any seconder? Mr. Chen Kim Po. Mr. Wong Ten Kwong, do you accept? Yes. Any other nominations, please? Are there any other nominations? No? Then Mr. Wong Ten Kwong, you have been elected as the chair of this Bills Committee. Thank you. If I may ask if you would like to have a deputy chairman for the Bills Committee, no need. In other views, no need. So we have decided against having a deputy chairman. Perhaps we should invite the administration's team to join us. Perhaps we need to deal with one matter. Mr. Charles Mock, after the expiry of the deadline to join the meeting, indicated his wish to join the Bills Committee. Any objection? No? All right, Mr. Mock, welcome. For the government officials attending today's meeting, we have Mr. Eddie Zheng, Deputy Secretary for Financial Services and the Treasury, Mr. Chiu Kwok-kit, Deputy Commissioner of Inland Revenue, Mr. Tony Chen, Acting Assistant Commissioner of Insurance, as well as Mr. Manuel Ng, Acting Senior Government Counsel of the Department of Justice. So, Mr. Zheng, would you like to walk us through the bill? Thank you, Mr. Chairman. Good morning, Chairman. Good morning, members. Maybe very briefly, I would like to tell you about the objective of the bill. I think it's rather technical in nature. For the Inland Revenue Amendment No. 3 Bill 2013, there are two purposes. First of all, we'd like to give captive insurers a concessionary profits tax rate that is 1/2 of the normal tax rate for corporations, which is currently at 16.5% for the business of insurance of offshore risks, with effect from the 1st of April 2013. And secondly, we would like to raise the deduction ceiling for contributions made by employees or self-employed persons to recognized retirement schemes. For captive insurance, it is a form of self-insurance by companies. So the insurance company is being set up by the parent company itself. This is to cut down on costs, and this is also to reduce the amount of premium. This is because the underwriting profits of the captive insurer can be shared. We would like to develop captive insurance in Hong Kong. In the FS last budget speech, he talked about giving concession he talks of giving concession to the profits tax As to the deduction ceiling for the contribution to recognized retirement schemes, we have already adjusted the maximum relevant income upwards to $30,000 per month with the enactment of the bill last year. Therefore, we need to come up with a technical amendment. So the deduction ceiling, as a result of the enhancement of the maximum LI from $25,000 to $30,000, it should be increased accordingly. In the past, it was $15,000 a year for a maximum RI of $25,000. Now, starting from the 1st of June 2014 onwards, the new requirement will kick in. And so for the deduction ceiling, it will be amended accordingly to $17,500. And then for the 2015-16 year of assessment, it will be enhanced to $18,000. So it is a bill with two technical amendments. We urge members to support the bill so that we have tax concession for captive insurance, and we hope that the self-employed as well as the employees can enjoy a higher deduction ceiling for contributions to MPF schemes. We welcome questions from you. Yes, you may ask questions. First of all, Mr. Andrew Leung. For the Inland Revenue Amendment number 3 Bill 2013, I do support it. Yes, there are two parts to it. First of all, there's one about the MPF. I think it's a subsequent amendment, technical in nature. And then for the BPA, we would also like to turn Hong Kong into a regional insurance hub, and we hope that there will be genuine captive insurance. The Deputy Secretary talked about the bill as technical. I think it's a policy issue. Now, it is said that the concession should be sort of given in such a way that it will be 1/2 of the normal tax rate. I support it, but I don't think that it should be regarded as technical. It is policy. For Section 39E, I think it is a policy. It isn't anything else. So why you give this tax concession to the captive insurers or offshore investment? For Section 39E, all along, we own factories on the mainland. Well, in the past, it was regarded as something against tax avoidance, but that's about the weapons. But then for 39E, we're talking about the acquisition of plants and equipment within the same group. For captive insurance, again, it is about companies in the same group. So please explain the rationale. If you can't convince us, then it is discriminatory. I do support the development of Hong Kong as a regional insurance hub. DS. Why is it that for Section 39E you are still such insistent as far as tax concession is concerned, while you are giving tax concessions for captive insurers? I would like to thank Mr. Leung for pointing this out. Indeed, it is a concession in terms of our policies. Perhaps I was too fast, or I was speaking too fast, and then I was actually referring to a subsequent consequential technical amendment in the light of the policy initiatives announced by the FS in his budget speech. So it is halving the profit tax rate. Mr. Leung is right in that regard. For 39E, I would like to defer to my colleague from the IRD. Mr. Chiu, Well, perhaps I would like to take this opportunity to talk about the government's position concerning Section 39E. I do understand that many participants in the industrial sector are concerned about 39E on many different occasions, including the Legislative Council. The administration has explained about the issue. For 39E, that's about the tax concession given to depreciation of plants and equipment. You need to meet certain basic requirements. So you need to meet the requirements concerning depreciation. First of all, the principle of place of origin. If we are talking about the machinery and plants used by a mainland enterprise, then it is subject to mainland tax. And I'm afraid it may not have a direct relationship with taxation in Hong Kong. The second question is about proportionality. A Hong Kong enterprise is different from a mainland enterprise. As far as the law stands, we are mainly talking about trading firm. For the mainland, it is really a manufacturing plant. Now, if the machinery is to be used in the process of manufacturing, I don't think it has really got a direct relationship with the trading firm in Hong Kong. And then the third point is about the international concern for the associations, the associates. If the associated transaction is part of a basket, then we need to follow the international standards and we have to split them up. Leasing of machinery across the boundary will have another implication. For the mainland taxation authority has already put forward its view to the SARG. So based on the above-mentioned 3 points, which are our principles, yes, we did give consideration to this matter, but we don't think that it is appropriate for us to extend the concession to the machineries used by a subsidiary of a Hong Kong company in the mainland. Let me say something before I comment on your principles. If you apply the 3 factors to a captive insurer, well, the company may be a mining company, but then for the captive insurer in Hong Kong, it is an independent company. So there's still the question of symmetry or proportionality. And then there is also this question of whether something has been transferred out. So I can't be convinced. So we're still talking about crossing the boundary. Now here it is called a captive insurer, but then back on the mainland, again, it is an enterprise engaged in some other activities. So you have said that those are your arguments. I hope the administration can think carefully. Don't cite one set of factors for giving the concession while citing another set of factors for rejecting the application for concession. Now, 39E used to be available, but then now you say that it is not. Now, if it is the government's policy to grant it, then go ahead. If it is your policy not to grant it, then make it clear. If you say that you would like to refuse it, give us the rationale. Now, I think Section 39E can be sort of implemented. Well, in fact, the industrial sector would pursue this matter. On this occasion, we're going to let you off, but come next time, if you come up with something again without showing that you have given this serious consideration, then you will have to face the consequence. Even us can engage ourselves in filibustering. It is not the prerogative of the Democrats. Well, I think the view has been expressed to you for a long time. You need to address the problem. Mr. Chen Kam Lam, Mr. Chairman, if I may ask this question in more specific terms. That is how we are going to implement the tax concession. Let me cite an example. Say, for example, I've got 500 taxis. Some of the taxi drivers who take out insurance on their own. To me, I think 500 taxis would involve a huge amount of premium payments. So I set up an insurance company to provide captive insurance for myself, to provide self-insurance. So how is this going to be implemented as far as the tax concession is concerned? Now, for this insurance company, it will be providing coverage to my taxis. Maybe I still need to get some coverage from other companies. So how are you going to do the calculation? When I have an insurance company, of course, I would like to extend the coverage to my neighbors, say, for example, their minibuses.
So there is two things. There is the captive insurance and also reinsurance business therein. How do you treat that? Mr. Chair, first of all, for the concession we're talking about is about offshore business of companies. That is to say, let's say a British petroleum company that has a number of oil fields in different areas, Gulf area, etc., around the world, and they therefore set up a captive insurance company to provide insurance coverage to these offshore businesses of theirs. And this is outside of the Hong Kong jurisdiction, and they will be given tax concession. As for Mr. Chan Kam Lam's example of Hong Kong taxis coverage, that would be within the jurisdiction of Hong Kong, and therefore they will not be entitled to this concession. I do not know whether I've answered the question. Mr. Chair, the policy objective is really to encourage more self-insurance for different industries. On the one hand, raising employment opportunities, and also it's very clearly explained here that self-insurance industry does not have to go through the intermediary, lowers cost of operation, and does not involve any marketing. And therefore you are encouraging of this. But why is it extended only to offshore companies? What about local companies, captive insurers that are local companies? Now, since you already have this policy, well, you would want to encourage such operation. My example just now was one thing, but let's say if I were a huge shopping mall owner, then I would have to take out insurance as well. For major corporations in Hong Kong, let's say, through self-insurance, through captive insurance, this is also professional insurance that they are providing, and this is true of all enterprises. Why is this only applicable to offshore companies and not to local companies then? Thank you very much for Mr. Chan's question. Mr. Chan is correct in pointing out that indeed there is no law forbidding us to not provide concessions to onshore risks coverage. But when we look into the history of captive insurance, we allow these offshore companies to provide the coverage of their companies by setting up these captive insurers companies outside of the jurisdiction of Hong Kong. If we notice some nearby jurisdictions or countries, you would see that they are also providing the same type of tax concession to this kind of operation, and therefore we have come up with this proposed amendment. If you're talking about local insurance companies and extending their business, because when we talk about captive insurance, the essence is really insurance business, and it is one and the same as other insurance businesses. And therefore, it will have to be extended to other insurance businesses if we are to provide concession to this type of business. So that begs the question of why we do not extend the concession to other insurance operations, and therefore we have limited ourselves to these offshore companies providing captive insurance, and therefore we have proposed for the tax concession to be as such. As for the future, well, we will be developing more tax concessions in order to develop the insurance business or industry in Hong Kong. We can talk about that at the time. Now, Mr. Chair, I have one last question concerning this particular tax concession proposal. if we are to adopt it and pass it, how much more business will we be generating in Hong Kong from that? Because as far as I know, every year it is about 100 million plus Hong Kong dollars in terms of tax collection from this source. I would like to know the tax impact. Thank you, Mr. Chen. At present, the Hong Kong captive insurance companies only number 2 in total. And the tax concession impact is really low as far as the impact on tax collection of the government goes. And for companies setting up captive insurance in Hong Kong, we have received certain inquiries, but as this is a new policy proposal of ours, and indeed I have to admit that we are rather late in Hong Kong in setting up this kind of tax concession compared to some other jurisdictions. So at this point, I would say it is not a very good assessment as to the tax collection impact. Perhaps after a couple of years when this is up and going, we will have a much more realistic assessment. So you are saying that you will have a better assessment after a couple of years of implementation. Yes, indeed, because the base is so small right now. Mr. James To, I'm looking at the background brief for the Let Show. I'm looking at paragraph 4 in particular, paragraphs 4 and 5 actually. It says that the State Council in June of 2012 had said that it would support the setting up of captive insurance in Hong Kong, and with the central government support, this can be developed further in Hong Kong. I would like to know whether we want to attract more mainland companies coming to the Hong Kong territory to set up these captive insurance companies. Is that the main objective of this law? Well, Mr. Chair, there is no territorial consideration for this particular proposal. That is for all offshore. Mr. Chair, I'm not talking about the law. I know how to read the law. I'm talking about the background. There are a whole host of things we can consider. For example, other jurisdictions. For this kind of captive insurance companies, I do not know whether they have certain tax concessions or what tax rate it is. Let's say a U.S. company, a captive insurance of a U.S. company. Would they set up in Hong Kong or some other jurisdictions or areas? Because there are a number of ways that we can compare tax rates and other relevant considerations in setting up these captive insurance. We are not talking only about the law. We have to approach from the policy objective point of view. I have read the law or the ordinance. My question is really, are we trying to attract mainland companies to come to Hong Kong to attract these, to set up these captive insurance companies? Well, in fact, the tax concession proposal is not something new. The industry had raised it to the government for consideration for, I would say, 7 to 8 years. And it is not because of the 2012 State Council policy that we have therefore come up with this hastily. Not at all so. And also for the Federation of Insurance in Hong Kong have also set up specific working groups to follow up on the feasibility of promoting Hong Kong as a captive insurance, self-insurance hub. And we have also done certain appraisals and assessments, and we feel that we can provide certain tax concessions in order to develop this area of business. And at the same time, it just so happened that in 2012 there was a policy coming out from the State Council, and of course we would want to attract mainland companies as well as any international companies coming to Hong Kong to set up these captive insurance or self-insurance companies. Yes, as Mr. James To had rightly pointed out, a lot of territories and jurisdictions have noticed the China mainland situation, and therefore we are in competition with other insurance hubs around the world and in the region. Well, Mr. Chair, that was not my question. Well, I think he's answered your question, though. Well, maybe I should put it this way. Compared to for companies which may have set up a captive insurance, self-insurance companies, I would like to know what the comparison is with other tax jurisdictions in terms of tax rate. Oh, is that what you're looking for? Right, right. And also, I would like to know for mainland Chinese companies, if they go to some other jurisdictions, are you asking about, let's say, the U.S. jurisdiction? Well, why is it a quarter deduction or 3/4 deduction? Why is a tax concession at this level? I mean, there has to be certain basis. Yes, Mr. Chair, we thank Mr. James Toh for the question. In fact, for some jurisdictions, they provide a complete tax holiday, zero. Can you name the jurisdictions? Singapore. Singapore is zero in terms of tax rate. Is that right for these captive insurance companies? Yes, indeed. If I can just refer to the information I have on hand, give me a moment. Singapore, zero. And in Malaysia, a particular jurisdiction called an island, and that's 0.5%. Qatar is no profits tax, and the U.S. also for certain states, because they are vying for this business. Delaware, for instance, the tax rate for insurance companies is 0.25%, and for reinsurance companies 0.15%. If you can provide all this information afterwards, yes, do provide that information. Now, if I can just analyze the information given for the mainland Chinese companies, please do explain why they are not going to the other jurisdictions offering the 0.15%, 0.25%. Why do they want to come to Hong Kong? Can you, from your policy point of view, explain why we are competitive with this proposed tax concession at this level compared to these jurisdictions which may be providing zero tax rate, etc.? Maybe for policy is that we will deduct by half as a first step, and if we already attract sufficient business to Hong Kong, and given that we have other advantages and strengths, Hong Kong, it may well be sufficient for us, or that we will go to a next step after that. Or is that your thinking, or are you just being arbitrary, setting it at half the original tax rate? Well, I'm sure you have careful considerations. Why is it not 25%, or why is it not zero? Please do explain why. You are asking for a paper to explain this. Yes, a paper, please. Mr. Leung Kai-Chiang. Mr. Chair, I would like to question the definition of qualified captive insurance business. These are non-life risks that are being covered, yes? Yes. As a qualified captive insurance business, does the business have to be registered and set up in Hong Kong, or can it be a branch of an overseas company? According to the ordinance, it has to be a company. Are you saying incorporated in Hong Kong? Yes, a company incorporated in Hong Kong. So for this captive insurance, this insurance company will have to provide self-insurance, that is reinsurance for some of the risks arising from the business within its own group. Then what about risks arising out of the group? Can they also provide coverage for those? No, they cannot. Simply risk within the group. What is the definition of the group? Well, under the insurance ordinance, there is a definition. Can you provide us the definition? Yes, a group company, a member of the group. For captive insurance companies, do they hold another type of license? Yes, they do, which is different from the license of the ordinary insurance companies. Well, we call it authorization. They're authorized to conduct certain businesses. In the regulation, we have life, non-life. So this is pure non-life, is that right? Yes, indeed. Mr. Chair, my question is, if this company insures or reinsures certain risks, the 8.25% can be enjoyed by these companies for offshore risks. And do you do an apportionment for the every year for the onshore and offshore risks of this group or the company? Yes, indeed, there is a formula in the ordinance. Well, that is clear then. Then the second question is on policy. A number of colleagues have asked why 8.25 and not 0, etc., etc. Before you came out with this draft, I have also asked the Financial Services branch, asking them why they have waited 7 to 8 years and now they're coming up with nothing but 8.25%. For certain qualified debt instruments, it is also at 8.25%. And I'm sure for the paper you provide to Mr. James Toh, you would be giving the same answer. I don't even have to refer to that. We're talking about Labuan, we're talking about Qatar. Singapore already has such volume of business. What you're trying to do is to attract new business. If you're slapping 8.25% tax on them, why are they coming at all? Well, in fact, I would put a CSA and make it tax-free for the first 2 years of operation for these companies in Hong Kong. Yes, a complete tax holiday for the first 2 years, and then 8.25 afterwards. How do you respond to that question from this question from Mr. Leung, which is very clear and specific?
Please give some consideration to it. I think this involves government revenue. So, Mr. Leung, can I consult your view? This will affect the government's revenue. Can we move a CSA? I think perhaps we are encroaching upon the government's prerogative. So for this CSA, I'm not sure whether you're allowed to move it. But then if it comes from the administration upon taking on board your view, yes, I hope the admin will consider it. But then you are the proponent. According to my understanding of the electricals business, you are not allowed to do so. But you can make a proposal. You can make a suggestion. If the administration take it over, then it's fine. If the administration doesn't take it over from you, it is impossible for you to move a CSA to that effect. Can the administration answer the question on the spot? If not, please give a reply next time. Mr. Chairman, if I may give a very brief answer. Well, to be frank, it is a policy direction. It is a choice. Mr. Leung is right to say so. Hong Kong hasn't had it before, that is, to provide tax holiday. Mr. Chairman, even though it hasn't been tried before, I think we need to get it. It has an implication on the revenue of the government. Mr. Leung's point is taken. Yes, Mr. Cheung, I think you are just giving us your answer off the cuff, so I suggest that you go back to consider in greater details within your bureau. Maybe we ask the bureau to give a written reply to my idea of providing a tax holiday. We haven't done it before. Yes, please give a written reply. Next, Mr. Chen Kin-po. Thank you, Mr. Chairman. I don't know whether Singapore has got Section 39E. The LegCo has been spending too much time to dwell on the Section 39E debate. I hope the IRD and the FSTB will quickly tackle the problem so that we can save time for something else. Now, for captive insurance, we are latecomer. Singapore has already started it for a long time. I think they've got over 100 such captive insurers. I think the government would like to catch up. This is too conservative. Why don't you just waive it? 8.5% is a far cry from a 0% rate. Well, I think your main point isn't so much about the tax revenue. You want to provide more jobs. You want to attract more investors. They will come to settle in Hong Kong. They need to find school places for the children. So I think everybody is doing the same. We are not just setting our eyes on the revenue. So my question is, why 8.5%? Why are you saying that 8.25% is still good enough to attract the captive insurance business? Mr. Chair, of course, the lower the tax rate, the more attractive it will be. When we considered the matter, we did take into account the advice of the tax experts. Now, usually we give a tax concession of 8.25%. So we're doing the same on this occasion. For the attraction offered to the captive insurers, we've been told that the regulatory framework of Hong Kong and the sound legal system are also very attractive to the companies which are considering the idea to set up captive reinsurance in Hong Kong. And also in Hong Kong, I think we are close to their headquarters, so it is a very attractive point. I've noted Mr. Chen's point, and we are providing a tax concession for the first time so as to attract the business of captive insurance. Perhaps after making the first step, we don't rule out the possibility of doing more. Personally speaking, among the members who are here, I think in principle all members are in support of the proposal. But as Mr. Leung, Mr. Chen have said, they think that we should do more. Mr. Chen is more aggressive than Mr. Leung. He's actually suggesting that we should drive it down to 0. Mr. Leung is merely asking for 2 years tax holiday, and the 8.25% rate can still be revived. I think it is true that we have started late and we have to catch up quickly. We want to attract both international as well as mainland businesses. So I think it's important to develop more businesses. We want to diversify the economy. So we shouldn't mind so much about the profits tax income from such captive insurance. Now, I think if you cannot give us, if you don't take this opportunity to do it, then at least you should review the exercise after running it for a period of time. Now, of course, you judge that the circumstances are such that you need to halve the profits tax rate. In the future, if it is found that this is not good enough, perhaps you really have to think of providing a greater concession. Any other questions? Ellen Leung. Thank you, Mr. Chairman. I would also like to express the views of the Civic Party. My understanding of the government's logic is as follows: to attract the business of captive insurance, it will always be good for Hong Kong. I think that must be the overriding policy consideration. Many members have spoken, and the chair has rightly summarized the sentiments. Now, we started late. It's like a race between the rabbit and the tortoise. So we want to catch up. And I want to know whether we can try to do more. Now, we have only got one or two such companies, and then the tax revenue gathered so far was said to be about $100 million. Even if we make it zero, as far as the tax rate is concerned, it is just a small sum of money. So if we want to be more assertive, we want to be more aggressive so as to catch up and narrow the gap, perhaps we should go all out and we should increase the magnitude of the tax concession. Mr. Chen, please reconsider our view. Mr. Chen for the second round. Now, members have been talking about the captive insurance only, and it seems that we haven't got anyone commenting on the deduction ceiling for contributions to the MPF schemes. Yes, we do understand that the amendment is supposed to be technical in nature. Now, the maximum relevant income level will be increased from $25,000 to $30,000. But then we all know that even for an income level of $30,000, at most the employees are the middle class. And we know that for the middle class nowadays, they have a heavy burden when it comes to their livelihood. They cannot get a PRH unit or HOS unit. So either they have to pay their housing mortgage, even if they don't have to pay for housing mortgage, it is still a heavy burden to have to pay the rent. For the MPF contributions, of course, we can save money for the rainy days, but then the monthly contribution will amount to over $1,000. Now, of course, if someone have money left, he can find a way to save it. Now you're making it mandatory. $1,250, no, $30,000. So to me, I think you are increasing the burden of this segment. $25,000 will regard them, anybody earning below $25,000, they are sort of in the low income group or medium income group. So what I'm suggesting is that the deduction ceiling should not be raised anymore. Now, the maximum RI has been raised to $30,000. For those earning $30,000, there's the personal contribution. So if we don't raise it any further, then we don't need to amend the Inland Revenue Ordinance because it's a consequential technical amendment. If you raise it further, it means that the higher income earners will also be affected. Well, I don't think it is the concern of this Bills Committee concerning the ceiling. I think that's for the FA panel. When we talk about the MPF contributions, then we should try to make a change. Well, we've got the relevant officials here. They are from the FSTB, so I think I need to reflect my concern. Today, I'm not objecting to the bill itself, but I hope that he will note our concern. That is, the income level should not be changed. Well, you know how I chair meetings. I don't like to discuss matters not related to the bill. Now, you are talking about the MPF policies. I've been tolerant. As soon as you try to digress, I have to ask you to come back to the theme of today's meeting. So you just note it and you don't have to give a reply. Next, Mr. Kenneth Leung. Mr. Chairman, if I may remind the administration the following, whether we're talking about fiscal policies or the taxation policies. Now, currently, you are providing some tax concessions. In the short term, you may have a lower level of revenue. For captive insurance, we wondered whether the rate should be 0 so that we get a tax holiday. What I want to emphasize is that you need to look at the medium term as well as the long term. You reduce the tax rate. You have to find out whether in the long term, as a result of more business opportunities elsewhere, the overall tax revenue will increase. I think that should be the most important factor for you to consider, rather than talking about in the short term you provide tax concession, you see the coffers will receive $100 to $200 million less. I think you need to have some projection 5 years, 10 years down the road. In particular, for captive insurance, we want to know whether by providing a concession, we can increase our income as a whole. I think that's the main point for policy consideration. Mr. Chairman, I've got other questions. Maybe they are not directly related to this issue. But first of all, let me make my point. And there are, in fact, 2 points. First of all, many of us who are professionals are worried about the company's ordinance reform. And then for a merger arrangement, now currently we have a vacuum in taxation arrangements. Like there are 2 companies, and when both are suffering a loss and when they are merged, I think this is related to captive insurance. When 2 are combined and when there is a loss, then the taxation regime is in a vacuum and there's no way that we can deal with it. I think it is a bit related, so I'll give the floor to the Bureau.
Mr. Chair, for Mr. Leung's question, in fact, the department and the IRD are looking into this. According to Clause 622, it talks about a group where there is a restructuring within the group. The company can inherit all the rights, assets, and other special privileges of the original company. And it is wide-ranging, and we are still in the process of studying it. And at the right time, we will be going to the industry concerning our views. We have asked all the questions, and with one opinion from Mr. Leung, and that is to say we have to give and take, perhaps give a little in order to benefit in a bigger way. So we should think bigger and provide more tax concession for these captive insurance companies. Members, for this bill, do we need a open deputation, or do we need to write to the 18 district boards and ask them to write in with their opinions? No, I don't think so. Yeah? No, no. All right, no. We do not. As for this meeting, can we then go to the clauses, clause by clause? Yes. Can we do that? Yes. If we can do that, we shall do that. Yes. Perhaps Mr. Chu can go through the amendments or proposed amendments with us. Yes, we are looking at Inland Revenue Amendment number 3, Bill 2013. For the purpose of the amendment, there are actually 2 points. The first is to provide captive insurance companies to be allowed the same tax concession as reinsurance companies, and that is slashing by half the tax rate. And secondly, for the maximum relevant income under MPF, the level had been increased, and therefore the tax concession or the deduction has also to be changed. And also a third point concerning tax, because the deduction is changed, the deduction level is changed, and therefore with the withholding part, we will allow the taxpayer to be able to enjoy the concession as early as possible. And so therefore we have parts 1, 2, and 3 to the amendments. Now, this is Inland Revenue Amendment Number 3, Bill 2013. And this is in Part 1. We also have Parts 2 and Part 3. The second part, Part 2, is the amendments regarding profits tax concession for qualifying captive insurance companies. As for Part 3, it refers to the amendments regarding maximum amounts deductible from assessable profits or income for certain contributions. And then it refers to 14D in Part 4. And these are qualified reinsurance companies. Under this 14D, we would also include captive insurance companies, and therefore we have extended the title of that part to reflect this. I'm sorry. What version, what copy are you looking at? Can we all look at the same copy, please? Yes. Can we perhaps look at the markup version? Can we all look at the marked up version? I think that would be easiest. All right. I'm looking at Part 2 now, Mr. Chair. I'm looking at 14B. I'm looking at the title of 14B, Qualifying Insurance Business. We are extending the title to qualifying insurance business and captive insurance business. And since 14B was only about qualifying reinsurance business, we will therefore have to add a new B. So there will be a Part A and a Part B. So Part B has been newly added, as you can see from the text on the right-hand side of the page. And also, there will be this section 23A bracket 2A referred to under this new section B. Yes, carry on. Because a corporation may have profits and it may also have losses, and therefore, for these reinsurance companies and captive insurance companies, because their tax rate is now halved, if in calculating their losses there is at the same time certain profits, then because the company had enjoyed the halved tax rate, then compared to those companies which are paying the full tax rate, there should be certain offsetting. Under 19CA, therefore, we have treatment of losses, concessionary trading receipts. At present, under the law, concessionary trading receipts include two items. One, those qualified debt instruments, which is not what we're considering now. The other refers to reinsurance business. This is 19C. But also, we are adding captive insurance business. And the only place where we can put this in is on page 5 under 19C. Page 5. 23A2 concerning reinsurance businesses. Because we have included the new captive insurance business, therefore we have to refer to Section 23A or 2A as well. In order to be able to deal with this in one go, Mr. Chu, can you please be short? Yes, we now go to page 6. 2 capital A, that's a new addition. So for loss, technically, we have also included captive insurance business with no other changes necessary. Now, as for non-life insurance corporations, this has nothing to do with them, and therefore there are no amendments. We go to page 8. Since we now have a new 2A, we have a formula for that, which is applicable to the captive insurance business, which is also the same formula applicable to reinsurance companies. And next page, page 9, we have only added certain punctuation and the word or. And then we go on. We have some definitions on page 10. These are completely in line with reinsurance companies, and we have therefore added nothing but captive insurance business. There's nothing new here. Our legal advisor has a question. Concerning gains or profits from offshore insurance investments, it refers to reinsurance as well, but in fact we are talking about capital insurance businesses only. Can you please tell us why under this definition we have to refer to reinsurance again? Because captive insurance companies can also conduct self-reinsurance business, and therefore the income will have to include reinsurance business as well. So that is to extend the business to reinsurance that is of a self-insurance nature, but it would not include businesses that are not self-insured in nature. That is correct. Mr. James To. Why do we have this amendment? Is it because of reinsurance or captive insurance companies? The latter, Mr. James To. I'm sorry I had to vacate the room just now, leave the room just now because there was another concurrent meeting, but I am back. I do not know whether someone had already asked this question. The question was asked some time ago in this meeting whether the captive insurance company can also conduct insurance business to cover other companies outside of the group. Can they do that? No, they cannot do that. And where is that enshrined? It's in the company's ordinance. The company's ordinance, the original, the existing. So the existing the insurance company's ordinance? Yes. It talks about the self-insurance, the scope of captive insurance. Well, actually, the purpose of this amendment is to slash by half the tax rate. There are no changes anywhere else. I just want to be cautious. Mr. Chair, yes, we thank Mr. To for the question. Section 2, subsection 7 of the ordinance talks about the definition of captive insurance companies. And in our licensing, there is also a type of license specifically for captive insurance companies. And the risks sustained by a captive insurance companies can only be risk arising from within the group of the company, and these risks would not include any legal required risks such as third-party risks for vehicle insurance or labor insurance. So these captive insurance companies, in terms of the definition and their terms of reference, is already enshrined in the Insurance Company Ordinance. Mr. Chair, captive insurance companies, do they have to provide insurance to the entire group? Because according to my understanding, this may not be 100%. Let's say the captive insurance company may be providing insurance coverage to a joint venture partner, 50-50 joint venture partner of a group company or the parent company of the parent company, etc. Is that possible? You understand the question, right? Well, according to the Insurance Company Ordinance, there is a very clear delineation of group companies. That is, all the companies within the group. If any of the shareholding of the company is between 20% to 100% owned, it would be considered company within the group. Why 20%? Why so lenient? Mr. Chair, we have to be careful. We're talking about providing tax concession. But if this is in the context of a very loose definition or very generous definition, well, of course.
Now, you have got this license, and yet it can take insurance business from all the group members, and then the tax rate is so lenient that and then the arrangement is so lenient that it starts from 20% only. Sorry, Mr. James Toh, you were not in the conference room a moment ago. Well, just now, many members talked about having a comprehensive concession. What do you mean? Now, the proposal is to cut it to 8.25%. Now, members who spoke said that when compared with other countries, for captive insurance, our competitors offer more attractive tax rates. In some cases, the tax has been entirely waived. Yes, I noticed that. Now, for captive insurance, we collected about $100 million by way of tax revenue from the captive insurers. It is believed that even if we waive the income, probably the economic benefits gained would certainly exceed $100 million. That's the view of other members. Now, to me, other than the technical point, I want to find out whether the definition is too generous. Now, your target is to halve the profits tax rate. I have to read it in context. In other words, we have to find out whether you're going to generate other problems. I'm sure we have to study this aspect as well. That's what I mean. Now, what you're saying is that as far as the definition of group is concerned, we say that the shareholding should range from 20% to 100%. You say that it's too generous. I'm not sure. I have to ask the government. Mr. Chairman, 20%. 20% is the starting point, but then it's not subject to tax concession. Yes, I understand your question. I'll give the floor to the Bureau. Well, they have to think in terms of the provision of a tax concession and then arrive at a conclusion as to whether 20% is too generous. Give us a paper. No need. I think they can try to see if they can satisfy you. For the definition of group in the insurance ordinance, well, we make reference to the definition in the company's ordinance. You will cover associate companies as well. So generally speaking, the shareholding will be 20% or more. Lower than 50%, then it will be a subsidiary. So all of them will be regarded as if it's more than 50%, it's a subsidiary. All of them will be regarded as group members. Maybe we wanted to cover as much as possible. We want to get as much information provided, reported as possible in relation to the group definition. But when it comes to tax concession, should we be as comprehensive or as generous? Now, for other places, maybe they have a zero tax rate and then they start with 10% when it comes to shareholding. I don't think it is a question that the insurance officials can answer. It's more for the companies. Well, you are not suggesting another structure, so you think that it is right. You can't simply say that because that is the definition in company's ordinance. You need to have a comprehensive view in mind and then judge whether it is appropriate. So I want them to tell us whether this is appropriate or not. Well, perhaps you can also provide the following information to James Cho as well. For other countries, when it comes to group, is the definition the same? Make it tighter if they have the same yardstick, and yet if we start to tighten it, then do you think that it is going to provide hindrance to captive insurance? Mr. Chairman, I hope that the admin would consider the matter from adopting your approach. Yes, please provide a written answer. Mr. Leung, I just want to repeat James' point. You mentioned Singapore, Malaysia, Qatar, etc. for their group definition for group in relation to captive insurance. Now we're talking about tax concession. They introduced it a few years ago. I want to know whether they have ever tightened up the definition for group. Now James' concern is that perhaps this might give rise to tax avoidance or tax evasion, or they come up with a very complicated plan to jeopardize our tax revenue. Mr. Chairman, sorry, there's one other question. Now, for the offshore risk, we are going to provide a tax concession. My question is, for offshore risk, is there a definition or not? Or we just rely on the common sense? Commissioner? Mr. Chairman, for the offshore risk, in the current amendment, I think it is mentioned. Yes, I think you see it on the first page. It's the definition. Page 10. Premiums from insurance of offshore risk or gains and profits from offshore insurance investment. It is offshore and in transit. I think these are the 2 points being covered. For others, it has also been defined in page 10, and then there's treaty insurance again defined in B. When compared with a definition for insurance, basically the definition is the same. Do we have a definition for offshore risk? Can you not define offshore risk more directly? I think it is a matter of fact. Say, for example, the real property is not in Hong Kong, so undoubtedly it is offshore risk. Or the batch of goods is moved from one mainland city to another mainland city, never passing Hong Kong, then it is clear that it is offshore risk. So the item of insurance coverage is not in Hong Kong. Yes. Please go back to consider this. please go back to look up whether there is a definition for offshore risk and then give us a paper and find out whether it is necessary. Well, for captive insurance, I think we need to be very strict about the scope of business. It must be offshore risk before it is entitled to the tax concession. For local business, it cannot be covered. Yes, I think we have to be fair to the local insurers which don't enjoy the tax concession. So a definition for offshore risk, please try to see if you can find it anywhere, and please write a paper for us. This way we can answer Mr. To's question. Let's continue. Page 12. Increase of the maximum deductible amount, and so there is a consequential amendment, Schedule 3B. Currently, the deduction ceiling is $15,000. It will be raised to $17,500 for the year assessment 2014-15. This is because the amendment to the MPFO will come into effect in June, and the same will be raised to $18,000 for the assessment year of 2015-16. So they're merely about the figures. Any questions? No questions? Then we can move on. The last part. We can go back to the previous part. Yes, Mr. Chairman, sorry about that. Well, I'll let you come back to your point. We can just move on. You just think carefully as to what you want to ask. Transitional provisions, page 13, Mr. Chairman. Well, when taxpayers pay the provisional service tax or provisional profits tax, we hope that the concession can be provided as early as possible. So for the assessment years, 2014-15, 2015-16, we have to make provisions for the provisional tax. For us to grab this business, Singapore, Malaysia, Qatar, and whatnot, they are in this game. What about the USA? I think they have got specific laws to compete for the business. I'm sure you are paying attention to their developments in the tax regime. It involves a lot of money. So I think it is worth the while to get Kenneth Leung or their peers to find ways to think of. I think you need to declare interest. Yes, of course, I am a tax advisor. I am not engaged in captive insurance, but it doesn't matter. I will just declare in any event. No, I'm commending him. They can think very carefully. They can think of all sorts of scenarios. Are there any cases? There is the IRD and the taxpayer go to court. I'm not talking about the case of Hong Kong. Has there been a court case between the tax authority and the taxpayer so as to identify a local risk being packaged as an offshore risk so as to avoid tax? I want to know whether you've studied such cases before you drafted the bill. So were there such cases? There is people abusing the tax concession for captive insurance. So do you have such examples in overseas countries? Did you make reference to such before you drafted your bill? For captive insurance and its tax concession, from the point of view of the IRD, we don't want it to be abused as a tax avoidance or tax evasion tool. For our tax regime in Hong Kong, it has a high degree of transparency. I say so. This is because we have got the treaty network, which is very comprehensive. We have already got 29 bilateral agreements so that we can exchange information. Say, for example, if there is an overseas enterprise wishing to make use of this tax concession for captive insurance to avoid tax, basically it can't be done because there is transparency. We'll have exchange of information to prevent that. That's not the question I asked. Say, for example, in the UK or the USA, let me say this, Mr. Chairman. I'll make it simple. Say, for example, there is a common law jurisdiction or not common law jurisdiction, and then they've come up with this law like this one before us. It's not for tax evasion, it's tax avoidance. The tax authority has said that this is not allowed. But then since hundreds of millions of dollars were involved, so there was a court case, and then the taxpayer won the court case. And then we turned a blind eye to that. And then it means that we are opening up a loophole. Others would abuse it. Now, to play safe, I want to ask the commissioner, the deputy commissioner, I think you're an expert, and the DOJ is also an expert. Have you seen such cases? Otherwise, once you introduce the law, it will be abused. You are accountable. Well, it's not a matter of outwitting each other. Taxpayers can legitimately, tax advisors can advise their clients in accordance with the law. So we will make it to look very silly if we provide a chance for abuse. So did you ever make reference to overseas cases? So are you creating a loophole for yourself? So if there had already been a case to the Privy Council, then you shouldn't have done the same. Mr. Toh, let me answer this question. We are now talking about offshore risk.
So the expense will not be deducted in Hong Kong, only the income, simply put. So for Hong Kong SAR, the expense would not be deductible in Hong Kong, but rather the income, because we want to encourage more business setting up for captive insurance companies. So we are really talking about the income from the premium payment. That's what we want to bring to Hong Kong. So, Mr. Chiu, your answer to Mr. Toh is that for this amendment concerning captive insurance companies, slashing the profits tax of these companies would not provide a loophole for tax evasion for Hong Kong companies. That's what you're saying. Can you please answer me, perhaps in the next meeting, whether there are such court cases arising over these captive insurance companies or offshore and over offshore risks, and where these cases were lost by the tax authorities? And if you say you have done the research and there are none such cases, then I rest my case. The previous question from Mr. Toh was seeking a definition, and Mr. Toh is now asking for any previous court cases over such tax conflicts. No, that's not what I'm doing. What I'm asking for is a case to illustrate this legislative framework. And if you say that, yes, we have referred to certain cases or precedents that went all the way to the Supreme Court, then we have, and after looking at these cases and examples, we have therefore designed the structure to be this way. And if you can just tell me that. As a electoral member, I am trying also to self-insure. Yes, I think they all understand you, Mr. To. They will provide the information and the papers in the next before the next meeting. Let us continue. Yes, let us go to page 15 of the document, Schedule 30, concerning the transitional provisions relating to professional salaries tax. And interpretation 1 refers to the year of assessment 2014 to 15, and 2 refers to the professional salaries tax. And paragraph 2, or bracket 2, refers to the $15,000, which is applicable for the year of assessment 2014 to 15, where that is exceeding $15,000, then this can be used to as a deduction in respect of those contributions allowable under Section 26G. And bracket 4 talks about the ground for the amount of contributions. Can you please stop here? Will the Inland Revenue Department voluntarily exempt the professional tax payments? Well, in fact, we will already use the new standard. So you will voluntarily do that? Yes, adopt the new standard. Exactly. Yes, we can go on. Mr. Chair, a drafting issue. If you can explain. Schedule 30, bracket 2. We're talking about page 16, brackets 2 and 4. There is a Chinese version, and the English version is, the ground is that, and it goes on. If we only look at paragraphs 2 and 4, we would not know what this refers to, but we'll have to read the entire stipulation. And this seems to be a new way of drafting. Cap 112 of the Inland Revenue Ordinance also provide this kind of professional arrangements. And if we look at 4, it is a bit more complete. It says that it is in order to implement 1B. So by reading this kind of drafting, we would know what relevant sections it refers to. But I wonder whether this is a new way of drafting, and that is there is no referral to the measure or the paragraph that it seems to qualify for brackets 2 and 4. Mr. Chair, in the drafting we try to be as elegant as possible, and we try to use plain language as much as possible. And therefore, in places where we see that there is room for using plain language instead, we will do so. If we look at the text there, we are trying to use a narrative style to draft the text. If you can look at the paragraph 2, the Chinese version says 有關理由是 the relevant reason is a direct translation of the Chinese version, but the word relevant is meaningless. If we put it into English, we will have to refer to other things. And this shows that we have already mapped out the reason in some of the parts of the bill. And it is only in clause 1, or bracket 1, that we say that person may apply to the Commission on the grounds specified in subsection 2. So given that given that this has already appeared, we do not feel that we need to repeat that again here in brackets 2 and 4. So we think that this is already clear enough. The relevant reasons in the Chinese version apart from legal advice, apart from thinking that this is different from the usual method of drafting, do you think the present method of drafting is clear enough and it conveys the intent? Well, if you look at clauses 2 and 4 on their own, they would not be sufficient. You have to look at, let's say, the stipulation in entirety, unlike bracket 1, which refers to the relevant part, i.e. subsection 2. So I'm remarking that this seems to be a new way of drafting, and if you look at brackets 2 and 4, you would not know what the relevant reasons are, because brackets 2 and 4 both refer to relevant reasons, and they are different relevant reasons. So you're saying that for bracket 2, it is related to bracket 1, in fact, isn't it? So they should spell out. Well, Mr. Chair, I'm saying that for drafting in the past, they would say in order to implement, let's say, bracket 1, therefore, and it goes on. To answer the chairman's question, we will have to look at the stipulation in entirety in order to be clear about the intent. Mr. Ng? Well, in the drafting, we have carefully considered it. We think that this is sufficiently clear and more concise, and therefore we have adopted this drafting. Legal advisor, do we object to this drafting? Well, if the legal department feels that this is concise and clear enough, we accept it. But we would want you to be very careful and cautious in your drafting, to carefully consider whether you are clear, sufficiently clear and sufficiently and whether the drafting is sufficient to convey the intent of the stipulation. Thank you very much, Mr. Chair. Thank you very much. Yes, we carry on. Page 16. Yes, 3 talks about procedures. This section applies to an application under Section 2, 1, or 3 of this schedule, and it goes on to talk about notice in writing, and then it refers to the time period of 28 days and then 14 days. So 28 days and 14 days are actually existing within the existing law. We go on to Clause 4, application for holding over payment of provisional profits tax on additional grounds. We were referring to income tax just now, and the same drafting is adopted here, and we are talking about 2014-15, which is in bracket 1, and the level is $15,000. Exceeds or is likely to exceed $15,000. Again, we see the same type of drafting, don't we? The ground it refers to in bracket 4 and bracket 2. That's right. Mr. Leung, Mr. Chair, actually for this drafting style, well, I understand that the legal advice had raised a question concerning this drafting style. If we look at Section 2, 1, 2, 3, 4, 5. Why do we have to put them into 5 different paragraphs? In fact, if we put them into one single part, it would also read well. Let's say if 1 and 2 are merged, then it may not be clear enough for the user. In fact, if you merge 1 and 2 and the rest into another part, then it would be very clear and it will flow much better. I do not know whether it has to be broken into 5 paragraphs. I actually do not understand, even if you say that this was the drafting that we have adopted before. Well, you are very practical, Mr. Leung. Well, Mr. Chair, I think we all have our different preferences for drafting, but I think the legislative intent had been conveyed here. Yes, we can continue. We go on to page 18, clause 5, supplementary provisions for application under section 4. This is again procedural. Bracket 2, the application must be made by notice in writing. And bracket 3, the application must be made not later than 28 days, and then 24 days that before the day and after the date, respectively. I think we've gone through the clause-by-clause amendments. Well, that's very efficient. We have further work to do after this meeting. For the question raised by members and opinions, we will want you to come back with written responses. And when these papers are received, would the Secretariat please provide to members? And until then, we will not convene another meeting unless there is any further progress in terms of your written responses. And only then will we convene another meeting. And if we have no further opinions after we have received the responses, then we will set the next procedure and the timetable thereof. Any other matters? No? Yes, we end the meeting here. Thank you very much for coming.